Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain and I am your host this evening. As our regular viewers are aware, this is a free legal advice show which aims to address your legal questions and provide you with answers and guidance in response to those. You can participate in the show in two ways, either by calling the studio and speaking to me live on air. This will allow me to ask any additional questions, clarify any issues arising from your initial question, and to provide you with guidance in the fullest form that I am able to do so. Alternatively, if you choose not to participate on air, but would still prefer to participate by sending a question through, then please do so on our WhatsApp group, the number you will find on the bottom right hand of your screen. As always, please remember that if you are sending a question through, provide as much detail as you are able to do so, which will allow me to understand what the issue is and how I can best assist you. If you prefer to send your question through in Urdu, then please feel free to do so, and I will address that as well. Any questions that are sent to must relate to English and Welsh law. I don't have the skill or expertise to address questions from other jurisdictions. However, I may be able to signpost you to other organisations which may be of assistance to you. I do have a caller online, so I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum.
Wa alaikum assalam, sister.
Yes, brother.
Yes, I got a question, sister. So basically, I have appointment tomorrow. I will have appointment tomorrow for biometric.
Yes, brother.
For my biometric. So actually, I did have received an email today from the Home Office saying that your meeting appointment has been cancelled.
Right.
But they have said my appointment is tomorrow, but they have mentioned your appointment on 13th of December has been cancelled.
Which was today?
But it was today, but my appointment is tomorrow. So can you please tell me what should I do, please?
And on what time is your appointment tomorrow, brother?
4:15.
4:15 in the afternoon?
Yeah.
What you might wish to do in those circumstances is contact. So the letter that you received initially will have a contact telephone number for you to contact in the eventuality that you're running late or you're unable to attend. You have most of the day there. It might be worth just contacting that number first thing in the morning and clarifying the situation with them. Generally, what we find is that most of these letters are templates. It could possibly be that somebody's just forgotten to amend the date, or they've got confused about which day they are writing about. But if they have taken the time to advise you that the appointment is cancelled, then there must be a reason to cancel that. Just to err on the side of precaution, just give them a call first thing in the morning, double check that it definitely is cancelled. Otherwise, you have plenty of time to make your way. Yes.
There's one more thing, please. Yeah. My solicitor has been also received an email for a reminder, but he received the email after half an hour after my email. So he have received an email for a reminder to please come to tomorrow appointment. They send you a reminder email to please do not forget your appointment.
Yes.
So I have also received an email after the cancellation. After half an hour, I have received another email which my solicitor has been received, and he said that you should go to your appointment tomorrow. So there is two things.
Yes, so it's caused a lot of confusion for you because on the one hand you've received a cancellation, on the other hand you've got
after that they
a reminder
email saying that you don't forget your email tomorrow, your appointment tomorrow.
Yes. The reminder emails are automated emails, which means that once the appointment has been put into the system, it is then set to send out this reminder 24 hours ahead of your appointment, and it's auto-generated. So there could be the possibility that the auto-generation hasn't been cancelled. I would agree with your solicitor. Ring them first thing in the morning, clarify whether or not you should be attending. If you're unable to get through, or if you are unable to get through, then make your way to the appointment. But hopefully in the morning you should be able to get that clarification and for certainty know whether or not you should attend.
Okay, thank you very much for that.
My pleasure. Thank you for your call, brother.
Okay, cheers.
Thank you. I believe we have another call on the line, so I will proceed to take our next call. Hello, assalamu alaikum. Hello, assalamu alaikum.
Alaikum salam. Sister, me and my friend, we submitted our application for under Zambrano roads in end of the June.
Yes.
Obviously, in December would be 6 months. My question is, he's got an appointment for the biometric, but mine one, I didn't receive any yet. My question is, because when I sent my BRP card to them, there was newly issued the same month or a month ago.
Yes.
So would they use the same biometric, or they won't need it? I mean, because obviously, like I said, the card was newly renewed.
Yes, brother. So they recently took your biometric details to issue another biometric card to you.
Because end of the June, I received in my BRP card end of July.
Yes.
For 30th of June, I submitted under the Zambrano route with my 2 British children.
Yes. So, brother, generally what the Home Office are trying to do is limit the number of biometrics they need to re-enroll. And they do have a policy at the moment where if they do hold recent biometric data, then they do endeavour to reuse that. They do decide on an application and a case-by-case basis. And so if the Home Office do require you to re-enroll your biometrics, they will be in contact. If they are able to reuse them, then they'll notify you of that decision as well. But the likelihood is that if you re-enrolled very soon before you submitted this application, then they will endeavour to reuse them. So just wait for that contact from the Home Office. Thank you very much. So thank you for that question, brother, and I hope you do get that resolved. We do have another caller, and I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. I'm so sorry, I think we appear to have lost that call. So in terms of the questions that we've had this evening so far, both of them have related to biometric enrolment. In terms of biometric enrolment, the Home Office will, excuse me, alhamdulillah, brothers and sisters, I do beg your forgiveness. In terms of biometric enrolment, the Home Office requires individuals making an application under the immigration rules or even outside the immigration rules to provide their fingerprints and their photographic details. Those details are then recorded on the Home Office's database, and they're always kept as a record of that individual. Any identity cards issued do have a microchip containing biometric information, and should that need to be checked by any agencies or authorities, then that can be done so by them taking fingerprints. And again, a lot of the police forces now carry a mobile fingerprint device so that they can check individuals' identities at the roadside. And so the questions this evening have related to appointments around enrolling those biometrics with the Home Office. One of our brothers unfortunately had lots of confusion with being told the appointment is cancelled, but the cancellation letter has the wrong date on it. And then subsequently his solicitor received confirmation that he should attend the appointment tomorrow. So we, again, the brother was advised to get some clarity ahead of the appointment tomorrow by trying to contact the Home Office in the morning before he attends the appointment. But it's important not to miss any appointments or contact arranged with the Home Office, as that can have implications on an application refusal to provide biometric data can lead to an application being refused or rejected, and so clarity must be sought in those circumstances. The other brother raised an interesting question which related to the reusing of biometric data. And the Home Office has recently introduced a policy where if they have biometric data from a previous application which can be reused for a future application, they will endeavour to do so with certain types of applications. And again, as I stated to the brother, they will decide on a case-by-case basis where biometrics can be used and where maybe there is a need for biometrics to be re-enrolled. And I am not aware of what criteria they use to make that decision, but each individual is notified in due course as to whether or not those biometric details will need to be re-recorded. We have a number of questions coming through in respect of the WhatsApp group as well. Just before we proceed to our break, I'll take one of those questions. So we have a question from a brother or sister here. My car was damaged by another car without a driver, as the other car rolled and damaged mine. The damage estimate is estimated around £500 or above. The owner of the other car has asked me not to use any insurance. Is it permissible to take money to repair the car or as a payment for the damage caused? So the short answer to your question is yes, you can. You can agree to settle this matter without having your insurance companies involved. Just make sure that you keep any receipts and that the damage is assessed appropriately. The issue that you may have is if the repair is not done to a satisfactory level, you know, who decides where you're going to get that vehicle repaired from. It might also be worth revisiting the terms of your insurance. You may be required to notify them if there is any damage to the vehicle, and without notifying them, that might nullify. We will be back at the other side of this break when I will continue to answer your questions. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We're now into the second segment of the show this evening. Just before we went to break, I was answering a series of questions from our brothers and sisters, some who called in live in the studio, others who have chosen to send their question through to our WhatsApp group. If you do wish to participate, either pick up the phone and speak to me directly, or alternatively do send your questions through. The show does go through very quickly and we do have a lot of questions, so if you do want an answer, please be quick in sending your questions through. Now, in terms of, just before we went to the break, I was answering a question from our brother or sister in relation to a car insurance claim. Just as a reminder, the question was in relation to a vehicle that has been damaged by a rolling vehicle, so a vehicle without a driver, and the damage is assessed to be in the region of £500 or above. And our brother or sister wanted to know whether they must notify their insurance company or whether they can settle the amount with the other driver without the insurance companies being involved, and the implications for that. And that was the question I was answering. In terms of whether or not you must notify your insurance policy, insurance company even, most policies now will require you to notify the insurer that the vehicle has been damaged. So, and again, you know, you must let them know what occurred in respect of the incident. The failure to notify your insurance policy is then the failure to notify your insurance policy in certain circumstances can void an insurance policy, and it may also have implications in terms of any future claims, because if the insurance company is not aware of any damage that's previously been caused, then in those circumstances there may be dispute about when damage has been caused to the vehicle, whether it was in relation to a previous incident that the insurance company wasn't aware of, or whether it's being caused by a future incident. So yes, there is in most insurance policies now a clause which requires you to notify the insurance company about the incident and what has happened. There can be implications in terms of the no claims bonus. Again, main thing is check the terms of your insurance policy. Make sure that there isn't a specific clause in there that requires you to notify the insurance policy. If you do wish to repair and settle this with the other party, and then there isn't a specific clause in your insurance policy requiring you to notify them, then that there isn't anything wrong with you doing that, and making sure that you keep accurate records in respect of the in respect of any repairs that are done. But again, most insurance policies on renewal or application will ask whether or not you have been involved in any previous accidents or incidents, and again, you would be required to declare those at that point in any event. So I hope that does answer your question, but do look at the specific terms of your insurance policy. Generally, you are at some point required to declare that there has been an incident, but you can financially not claim on your insurance policy, but ask the other individual to pay for the repairs to the appropriate level. We have another question. This questioner asks us, I hold refugee status for 5 years and it's expired 2 weeks ago. And I applied for indefinite leave to remain 2 months ago, and I haven't heard anything from them. My workplace is asking for my document to show my right to work. How long does it take for the Home Office to make a decision? And also, do I have to contact them as far as my employer is asking for my document? So again, thank you so much for your question. Now, there's a number of issues with regards to the question that you pose. The first one being your indefinite leave to remain your refugee status expired 2 weeks ago, but you had already made an application 2 months ago. Now, generally under immigration rules, you are not permitted to make an application more than 28 days before your leave expires. So in your case, you've made the application too early. Previously, the implication of that would have been that the Home Office would have rejected your application on the basis that it's not been made in accordance with the rules, as it was more than 28 days when that was made. Recently, there has been a change in policy from the Home Office, and the Home Office has acknowledged that any applications made more than the 28 days before any leave expires will be placed on hold until they are eligible to be considered. That then allows you to meet the requirements of the immigration rules, which you wouldn't meet otherwise, and then the Home Office will then consider the application. With regards to what happens to your refugee status, because as you state, your refugee status is now expired. It expired 2 weeks ago. That's not a problem. Under immigration law, an application that is extended or varied whilst you already have another form of leave in place is automatically extended up until the point that the Home Office makes a decision. So you will continue to be recognised as a refugee up until the point the Home Office makes a decision on your indefinite leave to remain application. At that point, you will either be granted your indefinite leave to remain settlement as a refugee, or if the Home Office rejects your application, you will be afforded a right of appeal, and then that leave continues until the appeal is decided. In legal jargon, that's known as 3C leave, just making reference to the legislation that affords that right. So you currently have valid leave to remain because you made your application whilst you still had refugee status. And this is why it's always important to note your deadline and make an application before your leave expires. If you make an application after your leave expires, then you do not benefit from the 3C leave that I've just mentioned, the extension, and therefore any benefits associated with the leave that you had previously are lost. In your case, your rights and responsibilities as they were when you had refugee status continue now up until the point that the Home Office makes a decision. These applications can take up to 6 months to decide. So if it sounds like you're in the very early stages, particularly if your application has been on hold, and it's unlikely, therefore, that you will have a decision for several months yet. If you made the application online, which you are now required to do, when you submitted the application, you will have received a submission confirmation. That submission confirmation will have contained a unique reference number. You can provide that to your employer, who can then access the employment check-in service and check that you do continue to have a right to work. You can explain to them why you don't have your documents, and also inform them that if they seek to terminate your employment on this basis, that would be discriminatory and that would be unlawful, which would give rise to an action in the employment tribunal. If you are legally represented, your solicitor should assist you with providing such evidence and maybe providing a letter for your employer as well. So those are the issues that arise from your question, and I hope that gives you sufficient material to work with to resolve the issues with your employer, because most employers don't understand these rules, and so it can be extremely difficult to persuade them that they should not terminate your employment. But as I say, you do have a right to work, and that must continue. Any further questions, any further clarifications, please feel free to send those through, and I will continue to answer those for you. So in terms of our brothers and sisters that don't understand this process, once an individual has a form of leave in the United Kingdom, and it's time limited, so there's a period of leave, but that will expire. So it's not indefinite, it's not permanent. It's the individual's responsibility to ensure that they are aware of the deadline, the expiry deadline, and that they do renew their leave before it expires. Unfortunately, sometimes there's a misconception that you need to wait until it has expired, and then individuals then try to submit a new application. The difficulty, as I say, with that is that once the leave expires, you've then lost all of your rights that you had associated with your previous leave, and essentially you then become an overstayer, and you remain an overstayer until the Home Office then makes a decision on the new application that you have submitted. So please ensure that you are aware of any deadlines, that you do then make a clear record, and do therefore arrange to make a further application. Best practice is no more than 28 days before your leave is due to expire. And that again in itself can have some serious implications. If you make the application too soon, you may not meet the requirements of the immigration rules. You may find that by the time the Home Office has filtered through your application and rejected it as invalid, your leave has already expired, which in itself can have some further implications for you. So try and make sure that you do seek legal advice, you understand what it is that you are required to do and when you are required to do it. And if you are unsure, then make sure you do not proceed until you have clarified your position, because the implications can be quite severe. for you, sometimes resulting in the loss of lawful residence, loss of employment, loss of housing rights, if you do become an overstayer. And applications can take, 6 months plus at the moment for a decision to come back. If you are an overstayer, they can be more complex and therefore requiring more time. And in all of that time, you've got uncertainty and potential destitution. We are proceeding to another break. So brothers and sisters, please keep watching and join me on the other side when I will continue to answer your questions. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining me this evening. I've had a number of questions which I've managed to answer. If you have a question that you wish to seek an answer to, then please send that through either by sending it through on the WhatsApp group or ringing directly into the studio and speaking to me live on air. Moving on with some further questions that we have. Again, I have a number of questions in relation to the rules relating to children who have resided in the United Kingdom for a period of 7 years or more, and the associated rights that their parents can apply for in terms of their leave. Rather than addressing your questions individually, a lot of them are similar in nature. I just provide some information in relation to the policy and the application process. So these are immigration-related applications, usually made by parents who have been in the UK for a number of years, generally without any form of status, most entering the UK as visitors or under some other form of leave, sometimes students, who have then not returned to their country of origin as required to do so, have been permitted to remain in the UK because the Home Office hasn't taken any enforcement action, and they have then subsequently started a family and now have children who have reached the age of 7 years. The parents then seek to regularise their status, their immigration status, and to persuade the Home Office to grant them leave to remain in the United Kingdom on the basis that they now have these children, known under the immigration rules as qualifying children, who have resided here for 7 years or more. So the rules in relation to such applications are contained within the immigration rules and specifically Appendix FM of those rules. And they require, firstly, the child is entitled to apply for leave in their right, in the sense that they have been residing in the United Kingdom for a period of 7 years and that their life is now in the United Kingdom. Most of these children are born here. They are in education in the UK. They have no knowledge of a life anywhere else other than the United Kingdom. Generally, most of them don't even know that they have no lawful status in the United Kingdom. That's a decision that parents made in terms of overstaying, not the children. So the children can apply for status in the United Kingdom on the basis of their 7 years residence, and evidence would need to be provided to show child was born here, the child is resident in the United Kingdom, hasn't left the UK, and what ties they have to the UK. It's helpful to have school reports, letters from school, and the older the child, the stronger the case. The younger the child, the more difficult, particularly with younger babies, although they haven't been here for 7 years. A baby doesn't know whether they're in their mother's arms in the UK or in another part of the world. And so any disruption to a younger child is less profound because their surroundings are their parents, as opposed to the wider society that they are a part of. As that child gets older and starts forming an identity of their own, their preferences, their rights and their welfare becomes a more pressing question. And the Home Office has a duty to safeguard the welfare of children. It's not an absolute duty, but it is the primary consideration that the Home Office is required to have. And so in those circumstances, the child would make the application, and on the back of that, the parents would also make an application, because if the parents can't stay, then technically the child can't stay either, because a 7-year-old child or an 8-year-old child is not going to remain in the UK by themselves. So they're generally the rules, and they need to be supported by strong evidence in terms of ties in the United Kingdom. So school reports, extracurricular activities, how that disruption will affect the child if they are removed, some evidence about life in the country that the child will be removed to. What's the education system like there? What kind of ties do they have, familial ties or societal ties, cultural ties? So there's a vast array of information that the Home Office will consider when making these applications. Now, the main thing to note about applications made under this route is that the Home Office will carry out an assessment about whether or not it is reasonable to remove this child. And again, there is an exercise there, a subjective exercise to some degree from the Home Office as to whether they think that it would be reasonable for a child to be removed. And again, a lot of the considerations that I have mentioned are taken into consideration. If a child has extensive family in the country that they would be removed to, then they will have and they're familiar with these family members. They have regular contact, they know who they are, they speak the language. Then it becomes less onerous on that child to integrate into this new society or new to them. And children are quite adaptable, and the Home Office will always bear that in mind. Most children will not have a huge amount of difficulty into adapting into a new lifestyle, into a new society. The second thing that the Home Office may consider is the level of education. The better the quality of education, for example, or at least access to education in a country, the more the Home Office will be persuaded that the decision to remove is reasonable, because that child's education will not suffer significantly in the sense that they can access education at the level that they need to. There are many countries around the world that offer free primary education. These children are usually in primary education level, and for that reason, it's also possible for the Home Office to say that it would be reasonable. So there are a number of factors which will affect the decision of the Home Office and whether or not they are willing to grant the child and as a consequence the family leave to remain in the United Kingdom. And make no mistake about it, the Home Office do look at these cases quite stringently. There is an element of deception. There is an element of deliberate rule breaking on parts of the parents when they choose to overstay in the United Kingdom, when they choose to then set up a family in the United Kingdom with the knowledge that they do not have the lawful right to be in the UK. And if the relationships are between adults only, then the Home Office usually are quite strongly in favour of removal, and the immigration rules and laws around it are quite strongly in favour of removal, on the basis that if an adult makes a choice, they would therefore need to be prepared to bear the consequences of that choice. And if the consequences of that choice are that you entered a relationship with the full knowledge, that you don't have the lawful right to be here, then that relationship can be moved to the country of the applicant, and they can reside there and continue that relationship, so should they choose to. The situation is slightly different where there are children involved, because children do not choose to enter that relationship. They don't choose to make those decisions. They happen to find themselves in a scenario created by the adults. And so the law recognises that the children should not be punished for the ills of their parents, and that will be taken into consideration. And so generally these applications are stronger when there are children involved. Any private life and family life applications where it is just the adults in a relationship, most often than not are refused unless there are serious compelling circumstances, which mean that the private life or the family life cannot be taken overseas. So those applications are the ones that we do get a lot of questions about. The application is made online. There are application fees to pay, and there is an immigration surcharge, and that's usually the next hurdle with these applications. So you've managed to get to the 7 or 8 year point. You are making the application. The costs can be quite prohibitive. So in terms of the Home Office application fee, that currently stands at £1,033. But there is also the immigration surcharge, which at the moment would amount to £1,560. So you're paying over £2,500 per applicant. So if you have mum and dad and also a child, you've already got £7,500 or thereabouts worth of fees. If you've got more children, then the fees go up with each applicant. And generally we find that most applicants in that situation just simply cannot afford to pay those types of fees, particularly if they've been in the United Kingdom unlawfully without the right to work. Most of their time has been spent in survival mode, and any income that's received is usually spent to provide for food and basic essential needs. There is a fee waiver process with these applications, again evidence-based, and the applicants then ask for the Home Office to waive the requirement to pay the fee. That's both the application fee and the immigration surcharge. If the family happen to have some savings, but not the amount to cover all the costs, then you may seek to ask for a partial fee waiver in respect of either the immigration fees or the immigration surcharge. But that would be advised on a case-by-case basis. Again, there is a high proportion of fee waiver applications that are refused, and you are therefore advised to seek legal advice, because that will assist in ensuring that your application is successful, and you can then go on to make an application for your leave to remain. So I hope that does help with the questions around the 7-year policy and how to access that. The key thing is having the right evidence for the right application so that the Home Office is equipped to make the right decision. If you fail to provide sufficient evidence, the application will be rejected. You will then be flagged up to the Home Office in terms of an overstayer, and an enforcement action is likely to then ensue against you and the family. We are now proceeding to another break. Please join me on the other side, where I will continue to answer your questions and provide guidance. Thank you. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you, brothers and sisters, for your questions. I do still have a number outstanding to get through for this evening. So inshallah, I will proceed straight to getting through those so that I can provide some guidance to those who have sent their questions through. The first question I have here is, Assalamu alaikum, sister. Alaikum assalam. I watch your program regularly. You do a great job. Thank you very much. I need your advice regarding my son's spouse visa. He applied for spouse visa. His wife is in Pakistan. Biometrics were done 5 months ago, but we have not heard anything. He tried many times to call them, but they say don't contact us unless your time is up. After that, they don't give any option and cut the call. They don't answer emails either. We don't know what else to do. Can you please advise us what to do? We really appreciate your help. Thank you very much in advance. Okay, so thank you so much for that question, and I'm so sorry that you find yourself in this difficult situation. With regards to spouse applications, most applications should be decided within 12 weeks. So it seems you are past the time that the Home Office specifies for those applications to be determined. And so there must be a reason as to why that there is this delay. 5 months delay is unreasonable. Particularly, as I say, when the Home Office's own guidance says that applications will be decided within 12 weeks. The best course of action in these circumstances is if you have tried to contact the contact centre, you have sent through emails, as long as you are sending them through to the right departments, and it is a paid for information line for overseas applications, and unfortunately it's quite an expensive information line to contact the Home Office in these circumstances. As long as you've tried the right routes, if you're still not getting an answer, you have two options. You may wish to get your local MP involved and see if they can seek guidance on your behalf and find out why there might be this delay. Your alternative option is to submit a formal complaint. Again, if you search complaints to Home Office or complaints to UK visas, you will find the relevant guidance there. There is an email address, or you can fill in an online application form. My experience generally is that they don't reply to your complaint or don't reply substantively to your complaint, but it does most often than not get the processes moving. So you will either end up with a decision or some kind of correspondence with regards to the outstanding application. But 5 months does seem a lengthy delay in my estimation, and therefore it would be worth exploring why that has happened. So that I hope that helps you with your inquiry. If I have missed anything, then please just send a follow-up question. So again, I've got another question. It's a similar question again. So it says, my son has contacted the Home Office to check the status of their spouse visa status. They replied, your application is still awaiting consideration or is still awaiting a decision. Can you tell me how long they will take to make a decision? Again, similar to the last question, 12 weeks usually for settlement applications. It is worth checking the Home Office website to see what information they're providing in terms of timescales. Sometimes there may be significant delays, and they may have altered those timescales. So again, just do a quick search in terms of application processing times for UKBA for a particular country, or UKVI as they are now, and you should be able to get that from their website. If you have been waiting longer than that period, then follow the advice I gave the last questioner in terms of contacting your MP or putting in a formal complaint, particularly if there is a significant delay. At least you've got an answer to say that they are still awaiting a decision. So it is under consideration. It's not just fallen off the bandwagon somewhere. So you should hopefully get a response soon. But if it is getting excessive, you're not getting a decision, then it might be pursuing that further. We have another question. This one is, I'm a British citizen. My fiance is from Turkey. We plan to get married in Turkey and apply for a spouse visa for her to come and live with myself in the UK. We've been together for almost 4 years and have been in contact every single day and have met in person countless times, but we've never shared an address together. How can I support our claim that we're a genuine couple? So in terms of spouse applications, there are quite specific rules and evidence that the Home Office requires. Your question is in relation to, specifically in relation to proving that this is a genuine subsisting relationship. Now, at this stage, at the spouse stage, the Home Office will look at certain key documents. So they need evidence that you have met. If you've got photographs from other visits, if you have, your tickets that to say that or to show that you've flown to Turkey at the times you claim to have met, then that should generally suffice in terms of information that you have met. And that's the requirement of the immigration rules. You'll also have your marriage certificate, which will confirm again that you have met, and your wedding photographs. So the evidence required in terms of the meeting, that's fairly straightforward. You will be able to demonstrate that by providing fairly basic documents that will be in your possession. Is the relationship genuine? Then most couples haven't usually been in contact for the period of time that you have, so the 4 years. So provide them with the evidence in relation to the contact, that this is regular daily contact, and that should be sufficient at this stage to satisfy the Home Office that you are certainly in a relationship. Now, that with spouse applications, the Home Office deliberately grants a probationary period of 2.5 years. So you would apply for your spouse visa, you would be granted 2.5 years, you then renew at the 2.5 year stage for a further 2.5 years. And that period is to demonstrate to the Home Office that this is a genuine subsisting relationship. And this is a relationship that at the end of the 5 years, you will be able to declare that you want to continue with. So it's almost a time to demonstrate to the Home Office that this relationship is going to work. And this relationship is what you're wanting. But for the initial stages, evidence of meetings, so photographs, marriage certificate, and also evidence of the telephone contact, evidence to show that you have visited your partner in Turkey or your fiancé in Turkey, and any other information that you're able to provide, particularly in terms of any engagement parties, and so forth. And that should be enough at this stage to satisfy that there is a genuine and subsisting relationship for the purposes of the immigration rules. So best of luck with that, inshallah, and I hope that does answer your question. Next question. So I have family issues. I came from Pakistan 21 years ago, and I've been married for 22 years. And we have 4 children, aged between 19 years and 11 years. We have been separated for around 7 months now. We have tried to solve our issues, but we haven't been able to resolve them. We have 3 properties, 1 on my wife's name and 2 on both names. My wife's side of the family don't want to give me anything, and I am living on rent at the moment. If I take the matter to court, where do I stand? My wife just has been working for around 5 years in this period. I have been working as a taxi driver now about 3 years. Now about 3 years and not working. So with regards to any assets where a marriage does break down, that's either a matter for you to resolve with your partner, and if you are unable to achieve any kind of agreement, then your next avenue would be to mediate those. There is a mediation service that can be engaged with, and that would be an independent party who would try and resolve any issues between you and your former spouse with regards to many issues, including any assets and how those are to be divided, issues around children and contact, and any other matters that arise from this separation. If you are unable to resolve your differences, then unfortunately your only avenue is to apply to the family courts for them to decide what happens to these assets. And the family courts will take into consideration many different aspects of the relationship, how these assets have been built. I mean, the fact that you say that your wife has only worked for a short period of this relationship, but then whilst you were working, your wife was also at home raising your four children. And so the argument being that if she wasn't at home raising the 4 children, she could have gone out and worked and she could have created more assets for herself. So those are the types of considerations that the court will look at. These types of matters are best resolved amongst yourselves. It saves you time, it saves you money, and it saves a lot of stress, and litigation should be at the very, very last resort. And if you can therefore resolve them, it is better. But as I say, the final point of call will be the courts, and the judge will then decide how those assets should be divided, taking into consideration the full family circumstances, who's contributed what, not just financially, but also in terms of the rest of the family life and the raising of children. There are children. Obviously, your wife and children will need assets as well, but you also need a fair share of yours. That brings us to the end of today's legal advice show. Thank you so much for participating and for joining me as you do each evening. I will be back, inshallah, next week. Please have your questions ready, and I will try to get through as many of those as I'm able to do so. Please look after yourselves and remember me in your du'as. Assalamu alaikum wa rahmatullahi wa barakatuh.